Congresswoman, Representative Hobbins, and members of the committee, thank you very much for the opportunity to testify this afternoon. I'm Patricia. I am the Commissioner of the Maine Department of Environmental Protection. I am a resident of Sheepscot Village, which is in the town of Newcastle. We are here today to provide you comments first on LD 1750 as drafted, so I apologize that my testimony was actually drafted on the bill as it was originally printed, and I will try to also speak to the amendment that has been distributed this afternoon as well. Following me is Mark Bergeron, who is our Director of Land Resource Regulation at the department, which is the actual division at DEP which undertakes the permitting, compliance, and enforcement of the wind power projects. Also here today is Director Patrick Woodcock, the Director of Energy, to also discuss items in regards to LD 1750. Though the Wind Energy Act is codified in statute at 35A in the Maine statutes, it's actually before the Department of Environmental Protection. We are the ones who undertake all the licensing, the compliance, the enforcement, as well as the related issues to those particular grid-scale projects. Smaller wind projects, in some circumstances, are also before the department, but today the focus is on the large-scale or grid-scale projects which come under the Expedited Wind Energy Act. I'd also like to remind the committee, because you may not be as familiar with the department's process as with some of the other agencies that you oversee, that our staff time on these particular projects starts with an application phase or permitting phase, but it doesn't end there. Our staff also undertake all of the work that may be related to appeals, and to date, all projects that have been before the Department of Environmental Protection have been appealed, whether they have been approved or denied. And then beyond the appeal phase, there's also the compliance and the enforcement. So there's considerable amount of staff time that goes beyond just the application phase in relation to these particular projects. These projects bring with them emotional and, for some involved, life-changing decisions, especially for those people who may live near these projects. I have, over the course of my 3 years, met personally with hundreds of these people, whether they are supportive of or concerned regarding wind power projects. I have undertaken a number of site visits, and I take their questions, their need for answers, and particularly their need for inclusion in this process that we have very seriously. And it is at the heart of some of the changes that the department has made over the course of the last 3 years. So let me walk you through some of the changes that we've made. Some have been discussed this afternoon, and then I will also try, if I might, Mr. Chair, to be able to take a time to the amendment that's been distributed this afternoon. In 2008, the Expedited Energy Act was established. The project of the Department of Environmental Protection since that time has been appealed to the Board of Environmental Protection, which is our citizens board that oversees appeals and certain licensing matters before the department. Attached to my testimony is the Board of Environmental Protection's annual report to the legislature. This year, they made a point to provide it to both the Environment and Natural Resources Committee as well as to this committee, because in the middle of that report is a section specific to wind energy. They have handled the appeals. They had a number of pieces of information they wished to share with the legislature, and they had also asked us for some of the issues that we see as emerging issues before the department, and so those are also contained in that report that they've provided to you. So there's been much consternation. There's been much confusion in regards to some of the changes that we have made recently. So first and foremost, let me explain why we made some changes. First and foremost, members of the public, whether they're in the organized or unorganized areas of this state, asked for and wanted additional opportunities to provide public input into the DEP's application process with these projects. second was the department's own experience with permitting projects since the Act became effective in 2008. And third was the need to ensure the statutory criteria as enacted in the Wind Energy Act was actually in our materials and being followed. So let me provide you with just a very brief synopsis. In August 2011, the department and I, as acting commissioner, established a new two-step public meeting process in order to provide expanded opportunities for the public to have inclusion within our process. Prior to that, the public had an opportunity for input at the very beginning of an application process, and then that was it. And then the department would finish its work and issue a decision. We now have a two-step process. They still have an introductory meeting where they ask questions and get information. The permitting process goes forward. The staff is analyzing all of the material that has been introduced by an applicant, and then it issues a draft analysis. That draft analysis becomes public, and the public is allowed to review it, and then we hold another public meeting in order to receive their comments. In fact, I was at one of those last week. I was in Maine Wednesday night, where there were 150 members of the public who wanted to provide comments to the department on a draft analysis regarding the Bingham Wind Power Project. That's where I was, because part of this process is the commissioner personally attends these to hear those concerns from members of the public. As I read the amendment before you, this public meeting policy, because it's a policy of the department, would stop. I do not think that that is an appropriate way to go forward in trying to include members of the public. Why again? Because this is a policy. It's non-adjudicatory, it's non-enforceable, but the amendment says policies of the department must go through rulemaking, so therefore the policy that I issued that simply said, please DEP staff, make sure there are two opportunities for public input into these processes would stop. Next, we noted that DEP application forms, which is the term that's used here, but quite frankly, we call them submission requirements, so bear with me if I use that term. The application forms had not actually ever been updated since 2008, when the Expedited Wind Energy Act was actually created. So we undertook some updating in 2011, which from what I can gather isn't at issue here today. In 2012, there were new noise regulations that were finally adopted by the Board of Environmental Protection, and those became effective during 2012. So that was another change that has occurred. And then that gets us to 2013, which appears to be the crux of the discussion today. We did update our submission requirements in 2013. And what we did is we wanted to make sure that those provisions in the Expedited Wind Energy Act, which are required under law but had never been noted on our application form, if you will, were actually noted. So these include shadow flicker assessments, safety considerations, tangible benefits, the decommissioning financial assurance amounts, fire prevention and response measures, the part-time and full-time jobs, the energy benefits for Maine citizens, the scenic character and visual impact assessment materials. So the way I read this amendment, all of those, even though they are absolutely required under the Maine law called the Expedited Wind Energy Act, in which we are simply saying, give us the information that's required by Maine law, would come to a stop until such time as we go through rulemaking. Last year, there was another law that was passed requiring best practical mitigation aspects. There was also provisions of that are redundant to our own public hearing and adjudicatory proceedings under the Administrative Procedure Act, and protection for Bicknell's thrush habitat. Since that law became effective October 9, 2013, I think that the amendment says it's retroactive to June 1st, 2013, so I'm not sure how I then can ask to make sure the Bicknell's thrush habitat is protected until I go through rulemaking to simply ask for the material that's already required by Maine law. So let me briefly just go through that one more time, because I think it's been very confusing with the auspices of LD1 being raised today. If you look at the original Wind Energy Act, which is Public Law 2007, Chapter 661, it specifically allows the department to request through submission requirements, which is what people here call the application form. And it lists what those are, such as the tangible benefit, the public safety, the scenic and visual impact criteria. And that law then further goes on to say implementation of this section does not require rulemaking under the Administrative Procedure Act. We maintain we were simply saying, please give us the material that's already required under the Wind Energy Act. We were doing it in a way that the law told us to go forward and do that, and so that's why we updated our application forms. I think that the intent of the amendment isn't necessarily to put a halt to all the work at DEP, but the way it is phrased, and this is the amended version today, it would make us go through rulemaking for a number of the other environmental laws that these types of projects are required to meet. Those are things such as our stormwater law. It's a law called the Natural Resources Protection Act. It's a law called the Site Location of Development Act. It is the requirements related to technical and financial capacity, some of which are already in rules. And there are also questions as to whether or not we would then have to do rulemaking simply to charge the application fee on these particular projects as well. So I dare say that we have some significant concerns with LD 1750 as it was drafted and originally printed, and I think that with time we would be willing to and would like to be able to update and amend our testimony relating to the amendment. And as I said, Senator and Mr. Chair, that following me is our Land Resource Division Director. He can go into the very specifics of how we do permitting, but I would like to just leave you with this thought as well before there are questions. We already take into account and have to issue written decisions, and those written decisions, if you look at them and how we do that, we make it very clear as to the third-party expert information that we receive and why or why not the department deviated from that particular criteria and information. Finally, I also am concerned that as the amendment is drafted, whether or not our consultation with our sister agencies who have a great deal of expertise, such as Inland Fisheries and Wildlife, such as the Department of Agriculture, Conservation and Forestry, and potentially also our state economist and others, whether or not then we would not be able to necessarily use their information in the way that we always have. So those are just in a short review some of the concerns that we have in regards to this particular bill. Thank you very much for the opportunity to speak at length this afternoon. I do appreciate the courtesy of beyond the 3 minutes and would be happy to answer any questions that I have or defer those that I can answer to others. Thank you.
Well, you're very welcome, Commissioner Arho, and certainly your input is important, so I wanted to make sure you had enough time to review it all. Questions, Representative Rikerson?
Thank you, Mr. Chair, and thanks so much for coming today. I look at these rules and I see things like stormwater, sound, light, visual impact, habitat. That all says environment. That sounds like the environment to me. But then I look at Section 28 and it says the required submission of projected impact on electrical rates in the host community. That doesn't sound anything like environment to me.
That's correct. And the way that the Wind Energy Act is written, it talks about the primary siting authority. And so when it was written, that would have either have been the Department of Environmental Protection or the Land Use Regulatory Commission. In that law, it then goes on to say, here are some submission requirements that applicants must provide. And if you look at the definition of tangible benefits, that definition has a whole laundry list of items.